Welcome to another episode of the Sharkcast on litigation risks management, where we explore why businesses are so frequently sued and how to mitigate and navigate the dangers lurking in these risky waters. Join us now as we welcome our host, Kent Schmidt, litigation partner at the law firm of Dorsey and Whitney.
Welcome to another episode of Sharkcast. Today, I'm really thrilled to be joined in this episode by two partners who I count not only as partners, but longtime friends. And today, we're going to be talking with Kimberly Neville and Bonnie Paskvan on the challenges and the opportunities for collaboration between in-house counsel and outside counsel. So welcome, Kimberly and Bonnie. Thank you for agreeing to be guests on Sharkcast.
Thank you. Thanks so much, Kent.
The reason that I asked these two talented partners, among many partners I work with, to join me for this episode is because of the unique perspective that they bring, not only in working with in-house counsel as Dorsey partners, but in their prior careers, prior phases of their careers being in-house counsel. So I think maybe just so we have a little bit of context, why don't you both introduce yourself by telling us what you do at Dorsey, but also give us a brief overview of your history as an in-house lawyer, and that'll give us some context for our later discussion. Kimberly, you want to go first?
Sure. So thank you for having me on your show. And I was a Dorsey partner and practiced for about 20 years and had an invitation from my favorite client, who was a publicly traded client, Franklin Covey, and you probably know them for the 7 Habits of Highly Effective People. And I had an invitation to go in-house and head their legal department, which I did for 3 years and loved doing so. I figured out a lot about myself, which is that I like the courtroom as much as I like the boardroom, and really missed being in court. So came back to Dorsey, returned to a litigation and advocacy role, and hopefully learned a lot and some new tricks along the way. So that was my experience. I served as the head of a legal team of 7. We did operations in about 90 countries and publicly traded, very sophisticated, interesting business. So learned a lot.
I know you as a litigator, but during that time, I assume, based on your description, were responsible for both litigation and all types of non-litigation matters, right?
Yes, we had responsibility for all legal affecting the company worldwide, which is, part of the joy of being in-house. You are the real estate lawyer, you are the employment lawyer, you are the IP lawyer, you name it. The whole firm and resources of Dorsey and Whitney, which I previously relied upon for expertise, they weren't with me in-house. They had to be in my little head. So that was, part of the learning experience always is you learn to be very well-rounded in your skill set.
I'm sure, and I'm very eager to hear about some more things relating to that, and we'll dig into that shortly. But Bonnie, let's hear from you about your pre-Dorsey life as in-house counsel.
Sure. So like Kimberly, I was a partner at a different law firm for several years before I went in-house 26 years ago, 8 months pregnant with my first child. So I was then in-house for 18 years, 14 of them at a publicly traded telecom company, and the last 2 of which I was chief legal officer for a wireless entity. And then I moved over to be general counsel for an Alaska Native regional corporation for about 3 years, and then moved over to Dorsey 8 years ago. So a little bit more time as outside counsel, but almost half and half inside and outside counsel, which I think, like Kimberly, you learn a lot of things when you're chief legal officer for a corporation, and it has an incredible range of needs, and it definitely helps you be better at issue spotting and looking at things from a more holistic standpoint than you do when you're an outside lawyer, and folks tend to look for more narrow answers in general. But now here in my role at Dorsey, I find my role is often outside GC, and I'm being used in the same way, and I'm using the Dorsey platform to help clients with that crazy myriad range of issues that a lot of, especially like the Alaska Native corporations have, because they do businesses, some of them in dozens of countries around the world in all 50 states. And so they have very complex needs that you wouldn't necessarily appreciate if you'd never been in-house working at so many different kinds of issues and risk spotting.
That's very helpful context. And, I'm thinking of the saying, I probably should have looked it up to have right attribution and have the saying exactly right. Maybe you can help me. A little trivia at the beginning. Have you heard the saying, if you want to learn about water, don't ask a fish? I don't know.
I don't know that saying, can't.
Okay. I have this recollection of it, but it comes to mind because I'm the fish in that. I've spent my entire career at Dorsey. I've never been in-house. And so I want to hear genuinely from you, not just as a podcast host, but as a Dorsey partner, always wanting to learn about how better to understand what the in-house life is like and what the role is like. So why don't I toss a question with a wide open topic. What surprised you most, Kimberly, about going in house when you cross that line and you go from being a seasoned litigator to being in one sense, jack of all trades, as you described? What were some of the surprises and adjustments? And I'm sure something to do with timesheets will come up as a positive. But
It's funny that you mentioned timesheets because my biggest surprise is I think there's a common misconception that in-house is a lifestyle choice or that, you have a good work-life balance. I think that is potentially true if you're in a large, sophisticated legal department or you can compartmentalize or have lots of support. But for most people, that's not the case. Most of us work hard, very hard. And in fact, I worked, in my view, harder than I did in firm life. And it's not that I wasn't productive in firm life. It was just that, we had over 1,000 employees. Any given day, someone could face an issue, whether it was sales they wanted to close, an employee dispute, it could be anything. The interests are as broad as there are people. And, you are really constantly accessible to people. And if they need your help, they need it now. And you are not blessed with 3 or 4 floors of help. You might have 3 or 4 people if you're lucky. And most of the colleagues that I talked to, that was their experience as well. They were very, very busy people who are constantly responding or being responsive to the business and working very hard. So that was the biggest misconception that I would, steer anyone away from who's considering, that aspect of career change or thinking that that's a solution. You really are, if you're a lawyer and you're dedicated to the craft, you're on the clock.
that's a great point. Bonnie, anything to add along those lines?
I couldn't agree more emphatically with Kim. I definitely work as harder, and travel as much or more in-house. And so I think there's a lot of kind of holy grail, oh, get to be GC and it's all going to be sunshine and roses. And it can be, and it's wonderful to be on a team. I would say the biggest thing I miss about being in-house is folks' reluctance to have the billable hour meter running when they contact
Mhm.
me, which they don't have that pressure if you're in-house and you're embedded. So I think that's the biggest change. And I think what surprised me the most about going in-house was the shift in lens that I was expected to take business realities and risk into account in everything that I did. It changed a focus from legal advice to overall enterprise risk management and how is my advice fitting in with our business plan, our business strategies? How can I help avoid litigation? How can I better automate the contracting practice? So like at the publicly traded company, I then worked to create 60 different templates so I wouldn't have to keep inventing the wheel each time and that those processes could be faster for the business team. Set up checklists, created a PowerPoint on how to read a contract for non-lawyers, went to risk management conferences to understand better, came back and said, okay, now all our operating lines, I want each of you to do an enterprise risk management overview pick your top 10 risks. What are mitigatable? What are not mitigatable? Are we thinking about those things? And I got a lot of pushback on that one, particularly from certain folks who had said, oh, it's a huge waste of time. And then they came back to me and said, you know what? That made me think about things in a very different way. And thank you for that exercise. So it was a big shift in role from here's my legal advice, you go plug and play it into your enterprise, to now I have to think about things in a much more global way.
You know, I've heard, because I spent my entire life at Dorsey, that at other firms with other partners, there are sometimes tensions that arise between outside counsel and their clients in-house. It never happens at Dorsey, certainly, but any insights on why those tensions can sometimes arise, maybe specifically stemming from not understanding the pressures and challenges of one another? I'll throw that out to whoever wants to take it.
So keeping it anonymized. I was surprised by outside counsel's lack of caring at times about the budgetary pressures and lack of advice about impact on brand and reputation in pushing for litigation versus how is this going to make us look in the community. So that was interesting and surprising to me. Another big surprise and tension with outside counsel was when one actually went to my associate and said, hey, this board member is under investigation by this other entity, which of course I should never have known and should never have heard that. So that person was on my do not hire list, because anybody that would break privilege in that way about another company's secrets and embarrassing facts, how would I feel like he would be more aware for our corporation?
Yeah. Kimberly, anything to add on why these pressures and challenges sometimes manifest in tensions between in-house counsel and outside counsel?
Yeah, I was very fortunate because I had excellent firms to work with, and generally things ran smoothly. I can say though, a couple sticking points, and in our nature as a publicly traded, information must be passed on immediately. And that's important. You might, especially if you've got a disclosure deadline coming up, something that needs to be reported, you absolutely must have current information. So the only time that I really recall getting testy with somebody is if you sit on something for 2, 3 days. That can be critical to your client for a lot of reasons, whether not just budget, but whether or not they have reporting obligations elsewhere, or if perhaps they're a government contractor, perhaps they're bidding on a big RFP, there might be things that they need to know about and know about in a timely manner. So I would say, always keeping abreast and keeping current and making sure information is reported timely matters. And, bills are the nature of the beast, right? Like we all have them, we all get them. No one likes them, but if you're going to blow a budget, that matters. That matters in any business. It particularly matters in those that report, you
Yeah.
know, that they're honestly, and I shouldn't say honestly, of course they're being honest, but they're accurately reporting their revenue and their costs.
Okay. That's very good answers. And, I think the word budget and costs have come up a couple of times, and that was really my next area of question because we spent a lot of time talking about how much something is going to cost. So let me give an outside counsel perspective. So here's the fish speaking now from my prior metaphor. Um, Preparing a budget, in my case for litigation, just involves so many inherent imponderables. Um, Tell me how many depositions the other side is going to want to take. Tell me how many motions they're going to file. Are we going to get to trial in a year and a half? Um, Tell me about what you've seen from outside counsel in the budgetary context that you really, really liked and what has been frustrating to you. I think you've already touched on that, Kimberly, in terms of deviations from the budget, but maybe expand on that some more. And we're going to be talking here about both litigation budgets and budgets for other projects. So if there's a distinction, go ahead and identify it. But what are some things that outside counsel can do better, specifically in the budgetary process?
So I think really the communication is key to the process because, I mean, anyone who's risen to head legal has hopefully been around the block long enough where they've seen that there's so many things we can't control, right? Um, you know, Facts change, witnesses change, things become bigger than you thought they would be, or things become smaller than you thought they would be. We all understand there's no crystal ball. I think though, if you know you're going to blow the budget, it that would not be a conversation you should hold till you send it with your bill. Get in front of it. Call your contact early and say, look, we've got a lot coming down. We've got some filing deadlines we didn't anticipate. Other sides not cooperating, whatever it is. There's good reasons why, but get in front of it like you would, and just communicates because there's usually stuff that I could do on my end to make sure I got in front of it and to plan with finance so that they weren't surprised. And maybe there were other things I could move. We had a substantial IP inventory, and that was something that, we would plan more a year out. And maybe there was something that if I knew I was going to have an expense here that was unanticipated, maybe I could move something here into a later quarter
Mm.
and control my budget and then keep myself in good standing with my finance team, right? So it was always in my mind something that facts, I was the litigator. Facts are what they are, and they're hard to control sometimes, but what you can do is message them appropriately. So that would be my advice is get in front of it early.
Bonnie, let's hear from you on the deal side. We talked a little bit about litigation budgets, but I know budgets are requested in all types of M&A and other smaller transactions. And I have far less experience with that. But sometimes when I am asked for a budget, even on that, I think, well, it's sort of like how many days does it take to go buy a used car, right? You could do it. You could do it in an afternoon, or you could do it in 3 weeks, and you could take it to three different mechanics. And I know that's probably a crude metaphor, but in terms of doing transactions and how much due diligence is the appropriate amount, um, how do you address those issues with budgets on M&A deals or other transactions?
It's probably the hardest thing for me to do is to realistically and accurately nail any budget with certainty and have it stick to that because of the thousand variables there can be, including who's opposing counsel and how organized are they and how organized are both deal teams to process information, bubble issues up to the top timely, how organized have their land records been, how organized has their IP program been, and so on and so forth. So one of our retired partners said, Bonnie, whatever you think it will take, multiply 3. And then you'll be probably closer to what it actually takes. And like in
It sounds like a
litigation,
good rule of thumb for litigation
it,
budgets too, right?
exactly. And partly too is just what is the personality of the person on the other side? How much are you going to have to chase that person to get to the answers? How responsive is your client and how organized are they in terms of doing more of the due diligence versus Dorsey doing the due diligence? And what does that all look at like? So maybe it's a bit of a pivot, but there are certain tools that we do use at Dorsey to help bring those costs down. If you'd like me to shift and talk a little bit about that.
Sure.
So I do have a lot of clients most clients are price sensitive. And so some of the things that we do at Dorsey, we have a pool of people that are called legal mind attorneys that I'm sure you're very familiar with, Kent. So they're contract attorneys, they're not Dorsey employees. And so we're able to bill them out at a much, much lower rate, but they are attorneys. So they're credentialed and they have skills. So that is one play that I use frequently to try and bring down the overall cost. Are there things that they can be doing like baseline benchmark policy drafting or attend meetings and do minutes for directors? Because I don't want to use AI meeting notes for director meetings because you're probably breaking privilege.
Yeah.
And there's also all the implicit bias issues that note takers can pay more attention to the people with the loudest voice who speak the most. So then you've got a lot of issues culturally around that as well. So
By
that's
the way, that
one.
sounds like another podcast episode. Interesting
Indeed,
topics.
indeed, for sure. So another way to try and bring costs down overall is to use AI, which I am a skeptic and I see a lot of issues with AI, but there are a lot of things that it can do well to help get things to a baseline for an attorney review to be appropriate. So that's another tool that we're using at Dorsey pretty extensively and doing a lot of training and testing and human review on all of that. But those are ways to try and bring the overall cost down.
So we've talked about thinking about cost from a perspective standpoint. At a certain point, I'm sure one of the least enjoyable aspects of in-house counsel is reviewing bills, retrospective. Not what's going to be on what's on the horizon and needs to be done, but what we've done for the last month. Um, can you each just speak briefly to um, the things that are sort of the red flags or the, I don't know, anything that goes from an annoyance to a, we will not pay for this because this is incorrect and this just isn't right. What are some billing do's and don'ts that outside lawyers would be uh, prudent to keep in mind from an in-house perspective?
Kim, do you want to take this one first?
Sure. A couple thoughts. Maybe they're pet peeves, but they were pet peeves I heard from colleagues that I interact with as well.
I want to hear it all, Kimberly.
Yeah.
Now's the
Um,
time.
my thought would be excessive timekeepers or changing of timekeepers. When it was frustrating to me when I hire attorney A, and attorney A has maybe attorney B or C supporting him or her. And then, I didn't like a feeling that I was getting practice done. So let's see who we can bring in who's really junior and let them try our case out. Or, hey, let's, so and so's got a better deal to work on. So let's bring in this person. That is, that gets transmitted in your bill. Excessive
Yes.
time for learning curve, excessive time for coming up to speed, for bringing people on. You should be able to hire your team really day one with confidence that that team's going to take you through to the end
Yeah.
of your problem. And so I would red flag that. That would be something that would matter to me. And then also just the notion that I was the training ground would also be a red flag for me. I was one personally, and I don't know that everyone would share this view, but personally, I was willing to pay for partner time. If I had made the decision that I was going to refer this out, it was largely that I either felt I didn't have bandwidth, expertise, or it was something that I needed outside eyes on for, whatever reason. And if I was going to bite the bullet and spend that money that way, I wanted to pay for the right answer, not for people to think about it, or to train
Yeah.
on it or analyze it. I wanted to pay for a result I had confidence in. So that would be my red flag. Bills are what they are. They're cost of doing business. But, if it was an easy problem to solve, I would have handled it myself, right?
Right.
So,
Right. Bonnie, anything to add on reviewing bills and the red flags or pet peeves or both?
For sure. Sure. And having been on the other side of the desk for 18 years and reviewing bills and hiring and firing law firms, for sure, to me, one of the things lawyers need to think about is this is almost like your monthly calling card to your client. You're communicating in a very detailed way with them about what you're doing. And I think a lot of lawyers don't think of their bills in that way. So some of the things that I found really annoying is if every task was always a 0.3 hour minimum charge. Hard to believe. Really?
Yeah.
Everything took at least 18 minutes? I don't think so. Or just the repetitive day after day, the exact same narrative description. Like, how is it that you spent exactly the same task day after day after day? Were you being efficient? Were you really thinking about it? How come it took so many days to do the exact same thing? It just would surprise me. To Kim's point about change out in teams, unfortunately, you can't always control that. People come and go. And so, as someone who's been looking at those bills on the other side for almost half my career, I'm very mindful about doing no charge time and writing off time and showing it to the client so that they're not thinking that they've had to pay someone to get up to speed when unfortunately someone's been poached or went on maternity leave or 1,000 different reasons why someone might be unavailable that you thought when you staffed that team up at day one that they were going to be your team for the whole project, but life happens. So
And
those are,
Bonnie,
go
could
ahead.
I just interject on that a question? Do you want to see on the bill that the work was done, but as a courtesy, we're doing a no charge?
Absolutely.
Yeah,
To me, I think if you're giving someone a gift, they should be
yeah,
aware of it. And
yeah.
that was one of the things that I've changed out. I was doing all discounted hourly rates, and then I realized people then just thought that was my rate. So now I'm using my regular rate and saying the courtesy discount on the front so people understand I'm actually giving you my time at cheaper than what I charge other
Right.
people so that they realize, and often that's on a progressive volume discount, as you know, Kimberly, that if people buy more of your services, then we're often more interested in doing progressive volume discount. So folks will hire us to do more and more of what their needs are.
Or as I call it, the Costco discount.
Okay, never thought of us in that way, but sure. Yeah.
Good. There comes a certain point in time in many attorney-client relationships where it becomes clear that this is not a right fit or expectations aren't being met. And I'd like to hear on this rather delicate topic of how you break up. Do you do you think that do you or when you were in-house counsel, most clients do the quiet quitting, or is it better to just be upfront and say we won't be using you again for this work, or we won't be sending we would prefer not to work with this particular lawyer at your firm. What's the level of discussion regarding quitting in whole or in part in terms of recurring engagements?
So I am deeply grateful when any of my clients are clear enough with me that a relationship isn't working with any particular person. And so I am always asking for good and bad feedback. How do we do on this? Is there something you would have liked handled differently? How are things? So that's one way to try and get that feedback. When I've broken up with clients, often it's where it's just not going well. They really can't afford the service. And so they're not giving me enough time to be responsive and do a good job for them. So I've gone to them and said, look, you've got this annual renewal cycle or RFP cycle or whatever. I'm not going to bid for your work anymore. This just isn't working. You're not using me enough that I feel like I'm going to avoid malpractice exposure. So here are some referrals to folks that are cheaper, not better, but cheaper. And I hope that works out for you, but this isn't working. I can't only have you call in the heat of the fire with no warning and the answer needs to be right now without research. It doesn't work. And I don't feel like I can do my best lawyering that way.
Yeah, that's a good perspective. Kimberly, anything to add on that?
I agree with Bonnie, and and I think Bonnie and I practice similarly, both internally and externally. And I was always one that if I had a problem, I was very fortunate that I didn't have a lot of them because we had really great firms and great partnerships that we worked with. But it it really didn't bother me to call the relationship partner who I usually had a relationship with outside of work. I knew them personally as well, and I had known them for years and known them by reputation as well. And it didn't bother me to call a relationship partner and say, we didn't get a good experience on this one. And,
Yeah,
and usually I found that, not only would I usually get, some type of discount or something to make it right, because people didn't want to hear that, but people were grateful to know that because as a
yes.
relationship partner, when you're building your own brand and building your own firm's brand, you don't want to be represented by someone who doesn't represent who you are. So, the one or two times I had to do it, to me, honestly, it was a very mutually grateful experience. People
Yes.
were glad to have that feedback.
Well, the primary purpose is to hear your perspectives of as in-house counsel, but I find it almost irresistible to not say that the quiet quitting is really frustrating because sometimes you work really hard to please a client and then you think, oh, I wonder why they're sending their work elsewhere. I wonder if there's something we could have been doing differently. And, is it fees? Could we have offered a discount? Could we have staffed it differently? And so I appreciate what you're saying, Kimberly, about a candid conversation. And I think the usual principle that communication and being upfront about things is usually the best approach applies here. Let
Mhm.
me ask a question that's very pertinent to my practice and this podcast and things that I write and speak about, and that is the prophylactic aspects of the job of in-house counsel, specifically avoiding litigation in the future, figuring out where the trap doors are that are going to result in litigation. As you know, I spend a great deal of time thinking and talking and writing about avoiding litigation. Um, what are some, and I think it's a concept that everyone gets, at least from a common sense approach. It's like preventive medicine to prevent the, more catastrophic event down the road. What are some ways that you think in-house counsel and outside counsel can work together specifically on avoiding litigation?
So I think one of the ways is to definitely try and get, to the extent the company has any leverage at all, to use their own documents rather than the other party's documents, and have them be clear and understood, and have things like dispute resolution. Are you going to have internal escalation before you go to mediation or arbitration or litigation? If you're going to go to litigation or arbitration, where would the venue for that be? Would it be in your backyard, or would it be, one was like in Europe? And I was like, I don't know how that's going to work out for the client. I'm pretty sure it's going to work out better for the other side if it's in their backyard in
Right.
Europe. So those kinds of things I think are worth investing in. So for better or worse, you can't always make someone else take your paper. If you're a big Franklin Covey, you're going to have a lot more market power than a small entity, right? And then, or if it's like a shrink licensing agreement, that, you're not going to negotiate with Apple to get different terms on
Right.
buying a set of Apple phones. But to the extent that you can use your own paper and understand them and have provisions that you like, that are clear and you're happy with, I think that's one way to make sure that there's truly a meeting of the minds and your client understands what they need to do and what the other party's going to do. So that's one way.
Very good. Kimberly, anything to add from you?
Yeah, I mean, so I think you spend pretty much, 23 of your 24 hours a day when you're, in-house or GC head of legal, um, trying to make sure you're effectively mitigating risk, which always includes litigation against the company. And I think the best thing you can do, at least my approach was, legal as a business partner was my philosophy. And, a lot of legal teams will want to sit in isolation. And no, you really have to know the business. You have to understand
Yes.
what you buy, what you sell, and who your players are and how they work together. And that's important. And so treating legal as a business partner and approaching, in-house practice with that mindset is helpful. And in my mind, it's just, prevention is always key. The best way to not get into a fight is to not be there. So, how do you keep your files? How do you keep your, are you up to date? Do you attend your CLEs and know about your current employment regulations? Do you know about your current environmental regulations? What affects your business and how do you know about those things? And one of the things I appreciated from outside counsel that surprised me, going back to your original question, was, we'd get the blogs, and I used to always kind of think those were silly when I was practicing. I was like, I don't have time to blog. And I really
Yeah.
liked those. And my colleagues really liked those. I've treated it like the newspaper. It was, hey, there's a new statute coming down. I need to know about this. Hey, I do have people in California. I need to know about this. So I appreciated that partnership with just getting people I thought were kind of looking out for things that might affect my business and letting me know about
Yeah.
it.
Yeah. Yeah. Prevention is, the old ounce of prevention's worth a pound of cure. And the challenge in our world is that things are changing so quickly.
Mhm.
New regulations, new restrictions, the landscape is constantly changing. So collaborating with outside counsel and having them be eyes and ears on what's happening and what you need to know. Super helpful. Well, it's great to hear that, Kimberly, because we put a lot of effort into those types of communications. And
I really appreciated it. And I mean that genuinely. I really appreciated it. And we even, when certain things would come down, and we have a change in administration, there's a flurry of activity that goes with that, regardless of what your business is.
right,
And, we found that it was very easy to subscribe to firm blogs and firm information and get, it was really a quick way to get your headlines. And you can always just say that doesn't apply to me, delete, right? But if you needed to know more about it, it was an easy click. It really
yeah.
was.
So I had in-house counsel ask me not too long ago to, I'm switching subject here, to um, a new topic, but to illustrate this, in-house counsel asked me a question or a request I've never had before, which is to update the ray line on emails to reflect specifically what the topic was. You know how the topic evolves as you
Right.
email over several weeks? And this in-house counsel wanted to have the always make sure they're updating the ray line so that when I go to search for an email, I'll be able to find it with greater ease. And I thought that makes sense. I don't do that. And so it brings to mind the question of perhaps not that specific or that out of the ordinary. Are there any habits or even small things that outside counsel can do, perhaps that we haven't talked about? We've talked about some broad issues and communication and all of that, but are there any sort of very small ways in which outside counsel can make your life easier as in your in-house role?
So I'm smiling because that's one of my biggest pet peeves, Kent, is that people don't update the subject line, as particularly if it still has exclamation point and
Yeah,
urgent. And the urgency went away 3 months ago.
that's
Like, I
right.
don't think it's still urgent.
That's right.
So I'm right there with whoever asked you to do that because I really do like the subject line to be whatever it's about. Because when I sort
Right.
emails, that's a helpful way to find whatever it is in the 10,000 emails a
Yeah.
week it seems like we all get now.
And
I
just to interject on that,
Yeah.
for outside counsel, the subject line of your email shouldn't be your client's name
Yeah.
because that
Yeah.
helps them exactly zero. So, be- like from our perspective, it's the client's name that's the
Right.
subject because that's at least the client. But if the subject line is your client's name, that's doesn't help them at all.
Yeah. Uh, so I would say the biggest thing that in-house people forget almost every single time to tell me is what's my deadline. So as outside counsel, I'm constantly saying, when do you need this by as an aspirational goal or a hard deadline? And what exactly do you want as a work product? Because in their mind, they may be very clear. They just want a phone call, they want an email, they maybe want a memo. Often folks will say, I want your opinion. They really don't want our opinion unless it's for a bank closing or something because it's such a stylized work product. But people use that word in the colloquial sense, not in a law firm sense. But I feel like that's one communication piece that often falls down is what is it exactly that you need and when do you need it by? And I think that's one thing from having been in-house for so long that I'm a lot more sensitive to that really we only need to answer the questions being asked. It doesn't matter all these other questions that I might find super interesting. If the client has a specific issue they want answered, then we better focus on that.
Yes.
And what kind of work product do they want? Because I don't want to do a memo if really all they want is a phone call or if all they want is 3 bullet points. And I think in-house people don't always have the vocabulary. So another thing that I often will ask is if they're going into a meeting or they're interacting with some third party, if it's an area they're not super comfortable with, do you want talking points? Do you want
Yeah.
me to ghostwrite the email? Do you want me to ghostwrite the letter for you? Because, for example, say someone unfortunately is getting terminated. That may be something labor and employment lawyers help with every day of the week, every day of the year at Dorsey. But for the in-house person, that's almost always going to be uncomfortable because it's someone they know. do you want talking points? And it's surprising to me, people don't always ask for that kind of specific work
Yeah.
product, although they would find it incredibly helpful and their face looks so relaxed when I ask them, yes, thank you. That would be so great because then I can go in the meeting prepared and know that I'm not going to say something wrong that will get me sued.
Yeah, Bonnie, you do that so well, I know. And I think the way I would summarize what you just said is sort of have a concierge mindset, like not just doing what you're asked, but coming alongside and figuring out, hey, can I, at a nice hotel, the concierge is like, do you want dinner reservations? Can I help you? Here's an umbrella, right? So you appreciate that type of service instead of just, yeah, here, bathrooms down the hall, right? Kimberly, I doubt you have any pet peeves or there's anything. No, no, please.
No, and like I said, we were incredibly fortunate. I mean, I really enjoyed my time in-house. I had a terrific client and I had terrific partners with my outside counsel and my team. So it was great, but a couple things that, I would give people as tips. Um, I agree with everything Bonnie said. I mean, knowing, because you're just processing mountains of email, and Kent, I agree with what you said too. I mean, getting your 50th email the day that says contract, you're like, which one? There are 85 on this. you know,
Yeah.
so it just kind of helping people stay organized is and how would you like to receive things, and just reciprocating that is very easy. A couple other tips I would give is one is I would always say, when we're at Dorsey, the expectation is you've hired Dorsey, you expect an A product for your
Mhm.
problem. And that's not necessarily the case. Not every problem is a problem that needs to go to Dorsey and Whitney. Not every problem is a problem that needs to go to a big firm. And not every problem requires an A work product. Sometimes we're okay with the C plus. This is a pass fail situation. We just need to bounce it off somebody. So really understanding up front, what does your client want? Like Bonnie already said that, and is this a situation where we're just looking for some kind of, quick, let's think about this quick, or am I on the right track quick? Do I need to think about something I'm missing here? As opposed to, I need the full treatise. So
Yeah.
understanding what your client wants, and being willing to give the B minus or C plus product occasionally, that will help you be a repeat player. And then I guess the other thought I would say too, and this is just mine, I totally respect it's a business judgment. I get that. Okay. It's always a business judgment, whether it's the CEO, CFO, whoever has to make a budget number. But you have an opinion, and you're hired not just as you're hired as a counselor, right? And part of your job is to counsel companies to make good decisions. And you can lay out my 3 or 4 options and say, yeah, and honestly saying I don't know is also an opinion,
Yeah.
but just getting here's the Cheesecake Factory menu, order what you want. That's not helpful. What would you do if it was your money, if it were your shareholders, if it were your employee, if it were your business? What would be your best instinct here? Yeah, I'm paying you because I trust you, you know?
Yeah.
So that would be a tip that I felt like those who got my repeat work and got priority for being shortlisted were those who would put a stake in the ground.
That's really good advice. And sometimes it's difficult, I think outside counsel has this sort of instinct of self-preservation that
Mhm.
sometimes keeps us from saying, I got to make the tough recommendation here, but you have to at some point in time in some of these cases. So,
It's
you know,
just that it's a recommendation. And,
Right.
yeah,
and people disregard recommendations of outside counsel every day, and they
right.
disregard recommendations of inside counsel occasionally too.
Yeah,
It goes with the business, and it's just, but you need to make your best effort to make your best judgment for your client, right?
yes. Well, as I had predicted, this conversation has been invaluable to me. I uh, I'm going to listen to it again, not just for quality assurance purposes, but because I think there's several tips and things that I can pick up and implement in my practice. And it's precisely what I anticipated would be the case when I thought of having you both as a guest. So I want to thank you both. But before we go, we have a segment at the end of Sharkcast that we call the deeper dive, where we talk about something non law related. And so I just love to travel so much that I think I'll just throw out the question here and see what your responses are. Is there any destination or place in the world that is you're at the top of your travel bucket list? Haven't been there yet, but would really, really like to go.
Oh, wow. There's so many I'd like to go to. We went to Italy last year, and that was the bucket list item for me. So I feel
What
like I crossed
cities?
that one off, right? But I think my eldest daughter has an interest in service and is going to Thailand this year. So I think I'd like to go back with her and next year when she returns
Okay,
and
excellent.
try that angle.
What cities did you go to in Italy?
We went everywhere. We were on the high school trip for
Oh,
class. So
Nice.
everyone, this is the other tip. If your kids are signing up for class, have them take Latin. So,
Yeah,
but yes, we saw Rome, we saw Florence, we saw Venice, we saw Assisi, we saw Verona. We were all over the place in 10 days. It was wonderful. So
sounds amazing. And so Thailand, is that scheduled or is it just
my
on the,
daughter's going this year as part of
okay.
a youth service project.
Oh,
And
that's this year. Okay.
this year, and then I think she'll return next year because she's very enthusiastic about that. So I'd like to
Okay.
accompany her one day. It's wonderful work they do. So
Terrific. Bonnie, you're in Anchorage. It was beautiful, amazing scenery, amazing adventures, all sorts of things to do. And I know that you have a very active lifestyle, capturing all that Alaska has to offer. But do you have any place that is on your bucket list?
sure. So I'm excited this weekend. I will be in Seattle applying for dual citizenship to be Croatian, as well as
Wow.
American citizen. So my hope then is it'll take a couple years, but my hope is then I'll be an EU citizen and have my Croatian passport and be able to spend more time along the Dalmatian coast trying out all the great Croatian food and wine and beaches. So Grandpa came over in 1909 through Ellis Island when he was 19. His brother was 16. We got the ship record, ended up here in Alaska. He was a blacksmith, worked in AJ Gold Mine. And so it's kind of a fun reverse path now to go back. And so my kids and I are all applying, and several of my siblings and nieces and nephews. So it's back to the home country, as it were. And then I'll be
Yeah.
visa free to, I think, 187 locations. So it's a cool thing because both kids did the Russian K through 12 program here in Anchorage. And then my son did Bosnian, Croatian, Serbian as a minor at Michigan, and Savannah did 3 more years of Russian in college. So I figure, the world will be their oyster too. So anyway,
Yes.
that's the big travel bug on my agenda to achieve that
Wow.
goal.
That's very ambitious. Well, good luck on all that. I'm not sure what all that entails, but that would be pretty cool. And I think those trips that you are connecting to prior generations and bringing, immigration full circle, those are pretty cool. Yeah. So, um, well, this has been a terrific opportunity for me, and I've really enjoyed the conversation. But our time is up. So, with that, I'd like to thank you both for being here on Sharkcast today and to our listeners for also tuning in. As always, I'm very indebted to the extraordinary team at Dorsey and Whitney for making this podcast and episode possible. For more resources on litigation risk and litigation management, please go to litigationrisks.com where more information can be found on these topics, including a book on managing litigation risks written by yours truly. Until next time, my friends, this is yet another reminder that there are a lot of sharks swimming out there in the murky waters, so swim safely.
This podcast is not legal advice and does not establish an attorney-client relationship or create any duty of Dorsey and Whitney LLP or those appearing in this podcast to anyone. Although we try to assure that the content of this podcast is accurate, comprehensive, and reflects current legal developments, we do not warrant or guarantee those things. The opinions expressed in this podcast are the opinions of those appearing in the podcast only, and not those of Dorsey and Whitney. This podcast is considered attorney advertising under the applicable rules of certain states.